Washington, the Supreme Court's refusal to help Donald Trump change the result of the 2020 election should come as no surprise for the very reason the president hoped to win the case. The court is conservative. That means the three justices who owe their seats on the nation's highest bench to Trump, as well as others nominated by Republican presidents, profess adherence to the Constitution and the precise text of federal statutes. They don't just make stuff up. So, when Texas, backed by Trump and a cadre of Republican state attorneys general and members of Congress, asked the court to block election results from Georgia, Michigan, Pennsylvania and Wisconsin, it stood no chance of prevailing. More, Supreme Court denies effort to block election results in 4 key states that sealed Trump's fate. The hallmark of conservative jurisprudence is respect for established law, said Michael McConnell, director of the Constitutional Law Center at Stanford Law School and a former federal appeals court judge appointed by President George W. Bush. No one should be surprised that the justices, like the Trump-appointed lower court judges in all these election cases, followed the law. Earlier, Supreme Court challenge to election results turns into bitter war between the states. The law took them invariably in one direction. For a number of reasons, Texas lacked legal standing because it has not demonstrated a judicially cognizable interest in the manner in which another state conducts its elections, the court said in its brief order Friday. The state sought to leapfrog lower courts by framing the case as one in which the Supreme Court has original jurisdiction. Principles of federalism dictate that states decide for themselves how to run their elections. Governors already had certified the votes, making the challenge tardy, if not moot. Millions of voters could have been disenfranchised if their legally cast ballots were discounted. Texas is asking the Supreme Court to take up a case in which it would have to find its own facts, in which it isn't remotely obvious why Texas is the right plaintiff, and in which time is of the essence, said Stephen Vladeck, an expert on federal courts at the University of Texas School of Law. The posture in which the factual and legal arguments were presented necessarily made it impossible for those arguments to be taken seriously, even by the justices who might otherwise have been inclined to do so. Earlier, Trump seeks to join Supreme Court lawsuit challenging election results in 4 key states. Like, share and subscribe my channel.